The designated hour having arrived, I call to order this regular meeting of Ansel Blink's Quorum Forum podcast, the podcast. Local governments need to do business in the chair. It's me, Daniel J. Bolin, on the agenda today. We have a really special episode. We're putting our case law update to the ultimate test. It's artificial intelligence versus Alex intelligence. We've tasked a cutting-edge AI with summarizing some recent critical cases affecting local governments and employers. Then our brilliant guest, Alex Cambiaso, will provide the real deep dive, correcting, contributing, and clarifying what the AI might miss. But first, let's take the roll. Joining us today, we have a litigator at Ansel Blink. She's an experienced advocate representing firm clients in a variety of matters with practice areas including local government, litigation, and labor and employment. She has extensive courtroom experience from her time as an assistant state's attorney with the Cook County State's Attorney's Office and from her civil defense work prior to joining Ansel Blink. She plays tennis, and we're going to ask her about it. Alex Cambiaso is here. Alex?
Hello. Thank you so much for having me today.
Welcome to the Quorum Forum podcast. Are you ready to take on the machines, the AI machines?
Let's do it.
Now, what's more formidable, the AI machines or one of those tennis ball machines that shoots tennis balls at you?
You know, that's a tough question, but I think I'd have to say that the AI machine is a little bit more formidable. You know, the good thing about a tennis ball machine is that it doesn't really learn and adapt like AI does. So I'm really interested to see where AI is going to go in these next few years, especially given all the ethical and environmental concerns that it raises.
I'm interested to hear what your tennis skills are going to do in the next few years. What do you? How often do you play? Where do you play? Is it doubles? Are you on the? Are you internationally ranked? What?
I am not internationally ranked, unfortunately. You know, it's been a little while since I played competitively. I play mostly just for fun with a few friends who I've found who also love to play tennis and used to play in high school or college. So one of our favorite things to do is just go find a Chicago Park District park that has some open tennis courts, get in line and just hit a couple balls, whether that's singles or doubles. Just depends on how many people come out.
That's very interesting. I also, at the time of this recording, it's the day after Labor Day, over the Labor Day weekend. I also visited a Chicago Park District facility, the Dog Beach. I was actually throwing tennis balls into the lake and having my dog retrieve them. Another dog stole the tennis ball and chewed it up. Have you ever done that?
I have not, but I have known a ball machine to chew up a ball and spit it back out.
Oh, so we really do have to look out for these tennis ball machines. Well, tennis ball machine, AI machine, we'll get to the bottom of this by the end of this episode. Behind the glass for our protection, engineer Rick is present. We have a quorum. Dear listener, it's time for AI, artificial intelligence versus Alex intelligence. We fed some recent important cases for local governments employers to know into an AI machine, and we're going to listen to the AI audio summary that they spit out, and Alex is going to comment on it. And why, without further ado, Engineer Rick, let's roll it.
Hey there, and welcome back to the Deep Dive. Today we're taking a deep plunge into a stack of really critical legal cases. These have just wrapped up, or, well, some are still in motion, across Illinois and the Seventh Circuit. If you're involved with a local government or maybe managing an HR department, this deep dive is pretty much custom tailored for you. Our mission is to unpack these rulings and not just tell you what happened, but really extract the most important nuggets of knowledge so you understand exactly why each case matters to you and, your daily operations. It's all about helping you stay well-informed quickly and thoroughly without getting too bogged down in all the legal jargon.
And what makes these cases particularly potent for our listeners, I think, is how they cut across both public service and private sector operations. They touch on these sort of universal principles of governance and fair employment. We'll be looking at 4 distinct scenarios, each presenting unique challenges, but also offering critical insights. We've got law enforcement accountability, the intricacies of municipal fees, that delicate balance of public transparency, and the complexities of employment discrimination.
Yeah. And so, Alex, what do you think?
Yes, that one was definitely a little interesting. It's interesting to hear, AI or robots kind of, they almost try to stutter a little bit like they're a real human.
Yeah.
It's such an interesting technique that they've done there that does make it seem kind of real, but also is just sort of a little strange.
A little strange, a little creepy. But that's what most listeners would say about my regular appearances on this podcast. Rick, why don't we start with the first case? It's going to be Veronica Hinton versus the city of Chicago. Roll it.
Imagine an undercover police officer. They're in a sting operation, right? But then, allegedly, they cross a line way beyond the scope of their duties, engaging in, private misconduct. Who's responsible? That's really the core question. Is Veronica Hinton v. the City of Chicago, Matthew O'Brien, and John Doe. This is a U.S. District Court case from Illinois, and it grapples with a very uncomfortable situation when an undercover officer's inappropriate behavior might not actually be considered official conduct that the city gets held accountable for.
Exactly. This case zeroes in on a really critical legal concept for local governments, acting under color of state law. Essentially, a city can only be held responsible for an officer's constitutional violations if those violations happened while the officer was acting with state authority. What's fascinating here is how the court just meticulously dissected the specific timing and the nature of the alleged misconduct to figure out if that authority was even present.
And the specifics of Hinton's claim, they reveal a crucial detail about how the court saw the officer's actions. Hinton claimed 2 Chicago police officers engaged in abusive sexual contact with her during prostitution stings after the prostitution offense had supposedly already occurred. And in both incidents, the officers, Bryant and Doe, they explicitly told Hinton they were not affiliated with law enforcement before the sexual contact. Bryant even got Hinton to agree to acts on the condition that he was telling the truth about not being a police officer. So, if he wasn't acting as an officer, what makes this case such a headache for cities?
Well, the court found that Officer Bryant's actions, specifically the inappropriate touching, did not occur under color of state law. And the reasoning was kind of multifaceted. The court characterized these as private acts, serving his own interests, not governmental ones. And importantly, not enabled or protected by state authority. He repeatedly disclaimed his authority right, making his behavior, as the court put it, indistinguishable from that of any private citizen before the arrest actually happened. Crucially, the misconduct happened after the prostitution offense was technically complete. It wasn't part of the investigation itself. The court called it self-serving opportunism. Pretty stark language.
Right. And because there was no constitutional violation by the officer deemed under color of state law, Hinton's claims against the city of Chicago, those Monell claims which argue the city itself is responsible because of a harmful policy or practice, those failed too.
Yeah, they fell apart.
The court even noted, look, 2 incidents just weren't enough to show a widespread pattern anyway. So the critical insight here for cities isn't just about liability, it seems, but about this very specific boundary the court drew between an officer's role and their personal actions, especially when they specifically deny that role. It highlights this precise moment where city responsibility can, detach.
Exactly. This case is incredibly important because it clarifies that boundary. It tells local governments that, look, an undercover officer's private, self-serving actions, especially when they deny their official status and act outside the direct scope of the investigation, they might not trigger the city's constitutional liability. It helps define the limits of vicarious liability for these kinds of incidents. However, and this is a big however, it also underscores the immense ethical and reputational challenges such incidents create, even without direct legal liability. It really highlights the continued need for very clear policies, robust training, and strict oversight to prevent these situations. Preventing these incidents in the first place is paramount, really, regardless of the liability outcome.
That was the AI summary of Hinton versus the city of Chicago, the artificial intelligence AI. Now it's time for the Alex intelligence AI. Alex, what did the AI get right, and kind of what were some of the details they might have missed?
I have to admit that AI did a pretty good job on this one. They highlighted a lot of the important facts and went through the law pretty well. One note that I would clarify is that, as the AI mentioned a little bit, but I just really want to emphasize, is that this case came down to whether those officers that had engaged in that uh, conduct, if they were acting under color of state law when they engaged in that conduct. Now, stepping back just a little bit, so under Section 1983 claim, a plaintiff can hold a public official personally liable for misconduct only when that misconduct occurred under color of state law. There's that same term again. That phrase is very important. So, to plead that a defendant acted under color of state law, a Section 1983 plaintiff must allege that the defendant's invoking of state authority in one way or another facilitated or enabled the complained of behavior. That's important, that facilitation or enabling. The court explained in this case that the officers didn't do anything that a private citizen couldn't have done. So, as alleged per plaintiff's allegations, there was no invocation of state authority that facilitated or enabled the officer's behavior. The officer engaged in this behavior, a random guy on the street could have engaged in that same behavior. Now, of course, we know that this doesn't mean that what the officer did was right, but it just means that what the officer did is not actionable under a Section 1983 action by plaintiff. So that's just something important to note, that this really comes down to that color of state law. And it, again, comes down to the facts, exactly what they did, and whether it was something that their authority allowed it, facilitated or enabled. So really, Dan, AI did a great job here.
I think you did a great job. I think it's Alex Intelligence 1, Artificial Intelligence 0, in my opinion. But I think some of the things you had to say was right. One of the big takeaways, I think, is not whether or not the officer, what they did was right, but whether the city should be responsible, and how the court evaluated that. And then even the AI mentioned this, aside from the liability outcome in this case, and what kind of policies and training and things that local governments can do to avoid these kinds of incidents from happening in their organization. So, few important lessons to take away from this case. I think it's time to hear about the next case. It's going to be Carter versus the city of Alton. Engineer Rick, roll it.
Shifting gears a bit. From the complexities of individual officer accountability, let's explore how cities themselves navigate financial accountability. Specifically when it comes to recouping the, very real costs tied to crime. Our next deep dive takes us to Matthew E. Carter v. the City of Alton. This Illinois appellate court case tackles a really common but often challenged aspect of local government administrative fees. Specifically, can a city charge fees for towing and impounding vehicles involved in crimes, and how do those fees hold up in court?
Yeah, this raises a fundamental question for any municipality, doesn't it? How do you recoup the significant resources, staff time, equipment, admin consumed by law enforcement activities related to crime without overstepping legal bounds? It's about balancing that fiscal responsibility with legal fairness.
So the city of Alton enacted an ordinance to tackle this. They charged a $500 administrative fee for vehicles impounded due to offenses like DUI. And they explicitly stated the fee was for partial reimbursement to the police department for time and resources spent on the whole seizure, impoundment, and release process, a crucial part of their ordinance. It guaranteed the vehicle owner the right to an administrative hearing to challenge the fee. And paying the fee didn't waive that right. That sounds like a pretty detailed process by Alton. But what if a city, say, can't produce studies like Alton did to justify its costs? Is the fee automatically in trouble then?
Well, that's a critical point for other municipalities listening, definitely. Carter, whose car was impounded after a DUI arrest, he paid the fee and then sued. He argued it was unconstitutional because, he claimed it only covered the minimal cost of writing a receipt, like pennies. But the appellate court upheld the dismissal of his lawsuit. They found the fee was rationally related to a legitimate governmental interest. And Alton had presented these studies showing a DUI arrest cost the city somewhere between $414.58 and $882.42. So the $500 fee was seen as reasonably related to these actual costs. That includes the whole process, the stop, investigation, seizure, impoundment, release, not just printing a receipt. The court also rejected Carter's due process claims, noting the city's administrative hearing process offered an adequate remedy. And they affirmed the voluntary payment doctrine. That basically barred his claim since an administrative remedy was available. That doctrine generally means, if you voluntarily pay a fee, especially when there's a clear way to challenge it legally, you typically can't sue later to get it back.
Okay, so this case affirms the legality of these administrative fees for vehicle impoundment tied to crime, but clearly with some important conditions. What specific actionable steps should local governments listening take away from this to make sure their fees can withstand legal scrutiny?
This case is vital because it really establishes a clear roadmap for cities. It's crucial, absolutely crucial, for cities to ensure these fees are rationally tied to documented actual costs. And not just for minor tasks like printing a receipt, but for the entire process investigation, seizure, impoundment. This means keeping meticulous internal records, staff hours, equipment use, administrative overhead for these specific types of incidents, or even, commissioning periodic cost analyses might be smart. And equally important, the ordinance must include a clear administrative process for citizens to challenge the impoundment or the fee itself. That transparency and due process, those are key to making these ordinances hold up under legal challenge.
That was the AI summary of Carter versus City of Alton. That was artificial intelligence. Let's hear from Alex Intelligence. Did the AI capture the court's reasoning? What do you think?
Well, yet again, AI did a pretty good job here. They highlighted well the important facts and the court's reasoning. I will say that maybe a couple facts were left out. I would say that the city of Alton in this case, they did have a system which set out the fees, and this was a 3-tier system of fees. The tier which applied in this case was just a level 1 fee. So it was $500 if a vehicle was towed in connection with an arrest for any felony or specific traffic offenses, which included driving under the influence. There were 2 other levels, which of course highlighted different offenses, which a car could be towed for. It could even be inappropriate parking in which your car gets towed. This system of fees would also apply there. So to determine if the city's fee system was constitutional, sort of as AI said, the court applied the rational basis test. And that requires that if there's a conceivable basis for determining that the statute is rationally related to a legitimate state interest, the law must be upheld. So I just wanted to highlight that the exact sort of term of art in terms of the law is that there must be a conceivable basis for determining that the statute is rationally related to a legitimate state interest. And if that is the case, then the law must be upheld. So the facts are really quite important here, as our AI hosts explained, because the city was able to point to actual exact data, how much it cost the city to prosecute somebody and impound a vehicle subsequent to a DUI arrest. They'd actually done studies in this case, which indicated, as our AI host said, that it was about $400 to $800 from DUI to prosecute a DUI from impoundment of the vehicle all the way to the end of the case. So the court really highlighted that the fee is rationally related if that amount bears some reasonable relationship to the actual cost it is intended to recoup. So the AI hosts here really highlighted that we should keep very meticulous records, and that's so true. We should keep great records, and we encourage all of our clients to keep good records. But we should also keep in mind that the fee just needs to bear a reasonable relationship to the actual cost. It doesn't need to be an exact Excel spreadsheet indicating how much everything costs and how many hours it takes for a staff member to complete this part of the process or this part of the process. You just need to be able to reasonably relate those costs to the fee that it is intended to recoup. So just keep that in mind as we go forward. You don't have to go crazy with recording all of your the records related to this, but do try to keep it in connection.
I I think that's well said. Again, another point for Alex intelligence over the artificial intelligence. It's 2-0 for those keeping score at home. The That was my takeaway from the AI, was kind of like a little over the top on what might be required to meet a rational basis, when it us lawyers and maybe some of our listeners know that that's kind of like a pretty low bar to clear of the kinds of levels of review a court might apply to the constitutionality of your uh, ordinance or fee. The rational basis test, like I think Alex mentioned it, it's like any conceivable rational basis. Like it's a really low bar to clear, and that $500 fee for tows is pretty common in across communities, pretty well recognized, well established, and there's been a number of cases over the years trying to challenge the fees like this, and the ones that I know of anyway, they pretty seem to be consistently, regularly upheld, as they were in this case. And I think there's nothing stopping you from looking at other municipalities' studies. To the someplace else did a study, you might be able to rely on that study to support your administrative fees as well. But of course, if you go out and do your own study and cost calculations to support your administrative fees, that's going to more likely clear the bar than if you hadn't. But yeah, I think the takeaway is you don't exactly need to be nickel-dimey about it to clear the rational basis standard. But a fine summary from both. I don't mean to denigrate the work that our AI hosts are doing. They're doing fine work, and I'm not saying that just because I wrote the prompt. But let's move on to the next case. What do you say, Rick? This is going to be NBC WMAQ Chicago versus the Chicago Police Department. It is a FOIA case, body cam case. Let's check it out.
All right, from the practicalities of city finances, let's move to the tension between transparency and investigation. The public's right to know versus the needs of law enforcement. Our third deep dive, NBC subsidiary WMAQ-TV LLC v. J. Kinney. The Chicago Police Department and the Office of Emergency Management and Communications highlights this often contentious relationship, especially when it involves media requests and ongoing police investigations.
Yeah, this case directly addresses Freedom of Information Act, or FOIA, requests for police records, including, importantly, body camera footage. And it focuses on the exemptions law enforcement can legitimately use to protect the integrity of their investigations. It's a constant tightrope walk, isn't it? The public's right to know, which is fundamental, and the very real need for law enforcement to protect investigations, protect witnesses, protect victims. This case really helps clarify where that line is drawn today.
So NBC subsidiary sought a pretty wide range of materials: surveillance video, incident reports, witness statements, POD camera footage, all related to a fatal hit-and-run crash. CTD and OEMC denied these requests. They cited FOIA exemptions that allow withholding records if disclosure would, quote, interfere with pending or actually and reasonably contemplated law enforcement proceedings, end quote. They also cited the specific Law Enforcement Officer Worn Body Camera Act for some of the footage. The records they withheld included things like body camera footage showing the victim and witnesses, cell phone records of the main suspect, POD camera videos, even an internal PowerPoint analyzing the investigation's progress.
And the police didn't just say no. They provided a detailed sworn statement from an investigator, Officer Niezbatowski. He explained precisely how disclosing each type of record would compromise the ongoing investigation. He laid out concerns about revealing investigative progress, allowing suspects to potentially evade capture or destroy evidence, and also the risk of harm or retaliation against witnesses. Real concerns. The appellate court sided with the police. They found the affidavit sufficiently detailed and case-specific.
Yeah.
They also rejected the argument that because the police released some limited information, like a basic traffic crash report, they had to release everything else. And importantly, they found that redaction wasn't required when the entire record itself was exempt under that specific FOIA provision for law enforcement records.
Now, what's really striking about this ruling, I think, especially for police departments and the public watching them, is how the court interpreted reasonable expectation of privacy, specifically in the Body Camera Act. It clearly stated this doesn't mean the same thing as it does in Fourth Amendment law, where generally you don't have much privacy expectation out on a public street. So what does it mean in this context for body camera footage? That's a good question.
Yeah, the court clarified that the legislature intended a broader meaning for the Body Camera Act. Much broader. It recognized that victims and witnesses, they might allow their encounters with police to be recorded, sure, but for law enforcement purposes. They reasonably expect, the court said, that these recordings will not just be disseminated to the news media or the general public. This is crucial for protecting witnesses from potential retaliation, and also for ensuring individuals, like maybe a victim receiving medical treatment captured on camera, aren't publicly exposed in these really vulnerable states. So, without written permission from those subjects, the body camera footage was properly withheld.
So for local governments, especially police departments, trying to craft their transparency policies, this case provides some really vital guidance. What are the key takeaways for them, boiled down?
Okay, I think two main things. First, this case underscores that law enforcement can, and probably should, provide detailed, case-specific justifications when they withhold investigative records under FOIA. They need to clearly articulate how disclosure would genuinely harm an ongoing investigation. So it's more than just checking a box. It requires thoughtful, documented reasoning. Second, it provides crucial guidance on body camera footage. It establishes this broader, reasonable expectation of privacy for victims and witnesses than we typically think about in public spaces. This ensures their protection from public dissemination without their consent. Ultimately, this helps police departments balance that need for transparency with investigative integrity and individual privacy. And that's essential, really, for maintaining trust and cooperation with the community they serve.
Alex, what do you think of the AI summary? And, well, what do you have to add or subtract?
Well, once again, they did a good job, as much as I hate to admit it, since we are being scored here, and I don't want to concede any points. I guess I could here, but they really did a good job. As they explained, the court had to balance those public transparency and investigative needs, and they did that by evaluating the affidavit of one of the investigating officers. As our AI hosts explained, that affidavit really had good case-specific detail explaining how each category of records was the disclosure of those would interfere with the ongoing investigation. And just to give you a little bit more information here on this specific case, this was a hit-and-run accident in which the officers were still hotly investigating this case. They did not have a suspect. They were really trying, and it would have deeply hurt their case if they had to let all this information out to the media. So that was important that they highlighted that fact. Additionally, as our AI hosts pointed out, they contrasted this situation where we got an affidavit from the investigating officer highlighting exactly how disclosure of this information would harm the investigation versus other situations, other cases where a municipality or a police department, some law enforcement organization simply says, no, you can't have these documents because there's an exemption, but I'm not going to say exactly why. I'm not going to give you more details. That's all I'm saying. So as our AI host explained, sometimes it can be very beneficial to give a little bit more information as to why things are being withheld. As to the body-worn camera video, again, AI did a very good job. One thing I will note that I found in the case, which was quite persuasive and thought-provoking, was that these body-worn camera videos, in this case, had been captured right after this hit-and-run accident in which a victim was seriously injured, and there were multiple witnesses on scene who had just seen a very traumatizing incident, a very serious accident. So these people, this isn't just a normal sort of interview or question and answer situation with a witness. These people were upset, and because of that, partially, they would expect that those encounters that were recorded were only going to be used for law enforcement purposes, not necessarily to be plastered all over the 5 p.m. news.
Right.
So the court was really quite specific that, the witnesses and victims have privacy rights here, and they had a reasonable expectation of that privacy. So these videos were only subject to disclosure with the written permission of those subjects or their legal representatives.
Well said. An important application of the Body Cam Act and an important FOIA lesson for us all. The detailed justification when you're claiming an exemption, you could see how far it went in this case. A good lesson to apply to any claim of withholding records under the Freedom of Information Act in Illinois. Let's take a look at the scoreboard. It's artificial intelligence 0, Alex intelligence 3 in my book anyway. Can she continue pitching a shutout? We'll have to. We have one more case, and let's take a look at Mitchell versus Exxon Mobil Corp. Engineer Rick, roll it.
All right, for the public's right to know and official transparency, we're going to pivot now to the internal workings of organizations. We'll focus on a critical area for literally any employer. How performance reviews can become, well, flashpoints for legal challenges. Yeah. Our final deep dive brings us to Carr Mitchell v. Exxon Mobil Corporation. This is a U.S. Court of Appeals for the Seventh Circuit case. And it examines allegations of sex discrimination following an employee's termination after a performance review. This is crucial stuff for any employer.
Absolutely. This case offers really vital lessons for employers on how their performance review systems have to be structured, consistently applied, and importantly, robustly defended to withstand legal challenges. Especially under federal anti-discrimination laws like Title VII, it speaks directly to the need for clarity and demonstrable fairness in those internal processes.
So Mitchell, she was a lab technician. She sued ExxonMobil, claiming she was fired because she's a woman. Pretty straightforward claim. ExxonMobil, however, maintained she was terminated due to poor performance compared to her peers in their annual assessment process. And that process sounds quite detailed. Self-assessments, coworker feedback, supervisors assigning preliminary categories. Then those categories get adjusted in these things called assessment group meetings. And these groups compare employees in similar roles and with similar experience, even if they have different job titles or work in different locations. They even have quotas for performance categories to ensure a kind of standard distribution. Now, crucially, Mitchell was a management assigned category, or MRC employee. This meant she was a new hire, but with significant prior experience. And this MAT designation is key because it placed her in a different comparison group, specifically designed for employees with similar backgrounds, not just compared to her immediate lab colleagues. Her D rating put her in a program that meant termination without benefits.
Right. And the Court of Appeals affirmed the dismissal of Mitchell's case. They found no sufficient evidence of sex discrimination, a key reason. Mitchell failed to identify truly similarly situated employees for comparison. Her male colleagues from the Sisser Lab, Pitts and Aguirre, they were not considered similarly situated because ExxonMobil's assessment system specifically put Mitchell, as a Massey employee, into a different assessment group. The court really emphasized that proper comparators must be directly comparable in all material respects. You have to rule out other reasons for different treatment. So this means your comparison pool needs to be genuinely equivalent in all the relevant aspects, not just, say, job title or location.
And even if she had managed to establish what's called a prima facie case, meaning she had just enough initial evidence to maybe suggest discrimination might have occurred.
Just enough to get past the first hurdle.
Right. She still couldn't prove ExxonMobil's stated reason for termination, that her performance compared poorly to others in her actual assessment group was just a pretext, basically a lie or a cover-up for discrimination.
Yeah, she couldn't show. It was phony.
The court explicitly stated it doesn't second-guess a company's business judgments about things like performance distributions. And Mitchell just had no evidence her performance was actually comparable to others in her specific EMEA group. Her claims about a supervisor's bias also failed, apparently relying on inadmissible evidence and even contradicting her own testimony. So for employers listening, what are the big takeaways from this complex system for their HR departments? What should they be doing?
This case, I think, underscores the paramount need for clear, consistently applied, and meticulously documented performance review systems. This means your HR department needs to ensure supervisors are trained not just on how to conduct reviews, but crucially on how to consistently define and apply these comparison groups, like ExxonMobil's MC system. That consistency is key to safeguarding against claims of unfair treatment. Such systems have to be built on clear, non-discriminatory criteria. No wiggle room for bias there. This documentation and consistency, really, they are your strongest defense against discrimination claims. It's all about demonstrating that your adverse employment actions, like a termination, are based on legitimate, non-discriminatory business judgments, not hidden biases, and showing that those judgments are applied uniformly across genuinely comparable groups of employees.
That was the AI summary of Mitchell versus ExxonMobil Corp. Now it's time for the Alex Intelligence. What do you think? Did the AI hosts get it right, Alex?
Well, yet again, AI gets it right. They really did a very good job here. A couple things I would point out are some of the critical aspects of Exxon's performance review system that led to the court decision. AI explained this a little bit, but I just want to make sure that it is clear. So in this situation, obviously, ExxonMobil is a huge multinational corporation. They have employees everywhere in the world. So employees are placed into assessment groups with employees in similar roles and similar experiences. So that being said, employees in that group might have completely different job titles. They report to different supervisors. They work in different locations. They're all the way across the country. Maybe they're in a different country. Who knows? That being said, they had to be similar enough and have those similar enough experiences in terms of their work that they're placed into this assessment group. So it's not necessary that those people are the coworkers of the employee that they see every day. The employee might think, well, only people in my exact office that I go into every day are, really comparable to me. But the court found here that that's not necessarily the case. Additionally, Exxon had a robust formalized performance review system, and that really helped them make the argument that they had not discriminated against the plaintiff. Exxon was able to articulate legitimate, non-discriminatory reasons for its decision. And then when that happens, the presumption of discrimination under the law falls away. And at that point, as our AI hosts explained, the burden shifts back to plaintiff to show that the employer's stated reasons for her adverse employment, being fired, was pretextual, as our AI host said, phony. So a pretext is just, a excuse you give to say that why you did something, but it's not really the real reason you did something. You're just kind of trying to cover to say, oh, well, actually, we did it for this reason, but it's actually just pretextual. So as AI highlighted, there's a lot of good lessons that employers can take from this. Once again, keeping good records, always a good thing, everybody. Keep good records, even if that's just, notes, not necessarily forms or something like that, but just good notes. Keep notes about this sort of thing and why you make certain employment decisions. Additionally, if you don't already have a formalized performance review system, you should really consider developing one. Because in this case, that really showed how that formalized system was able to shift the burden back to plaintiff. Then she had to show that the employer's reason for the action was pretextual and actually based on her status as a woman, or in any other situation, any other protected status. So lastly, make sure you evaluate employees against other similarly situated employees. And remember, that doesn't mean that they have to work in the exact same office or exact same location as the employee. They can work in a different office, but be very similarly situated. And additionally, make sure that you apply that formalized system in a formalized way. Apply it equally to everybody and make sure that you keep that system in mind when making all employment decisions.
I thought it was interesting that the AI host used the word meticulous again with the record keeping. I'm sure that meticulous record keeping did help carry the day in this case. But I think the takeaway for most employers would be having that formal process and just keep maintaining records in the normal course of your business to help establish the and defend the decisions you're making as an employer. I don't know, but that I'm not sure uh, meticulous is the right word. But yeah, record keeping did help carry the day for the employer in this case. And speaking of carrying the day, the scoreboard again. AI did do a good job, better than I expected, honestly, when I threw this together and punched it into the robot machine. But heck, I would not have understood it as well or made it through without the assistance of Alex intelligence. So it's a 4-0 sweep, AI over AI. Congratulations, Alex. Let's throw to our AI hosts for their final thoughts, and then we'll get your final thoughts in these cases. Rick, roll it.
Wow. Okay. That was a truly comprehensive deep dive into 4 critical legal cases, each offering direct, actionable lessons for local governments and employers alike. From how police accountability is defined down to the nuts and bolts of municipal fees, that tricky balance of public transparency, and the rigorous standards for defending against employment discrimination claims. The legal landscape is just always shifting, isn't it? And staying informed is probably your best defense.
That's a really powerful point because it's not just about avoiding lawsuits, is it? It's about cultivating public trust, ensuring internal equity, and ultimately building more effective, fair, and resilient organizations in the long run.
Absolutely. And for you, our curious learner, maybe consider this as you go about your day. How might these rulings encourage your local government, or maybe your employer, to reevaluate their policies and practices? What specific proactive steps could be taken now to prevent future legal challenges and foster an environment of fairness and transparency long before a lawsuit ever comes knocking? That's something to ponder. Until next time, keep digging deeper, keep asking questions, and keep learning. We'll see you on the next deep dive.
Hey there, Alex. That's the final thoughts from the AI in these cases. I'll invite you to share your final thoughts. But I think one of the takeaways that they buttoned up at the end there was, we're not just sharing these cases to help you win lawsuits, although we do love winning lawsuits. It's one of Alex's favorite things as a litigator to do.
Yes, it is.
But the reason that the law is the way that it is that it these kinds of lessons that you apply from these cases can help you run a better organization. What do you think, Alex?
Yes, I totally agree. I think the two big takeaways here are meticulous records. No, just kidding. That's what our
Good records, reasonably suited to the task at hand, whatever that may be.
Yes, of course. Just teasing our AI hosts here. Their little obsession with the word meticulous. But no, I agree. These cases are very important to think of for our municipal clients. The best defense is a good offense. So thinking about these problems before they arise are really is really key. And by educating yourself on these cases, even just at a cursory level, can really help you to think about these issues as they come across your desk and before it gets to litigation, so that hopefully some corporate counsel or whoever you seek your legal advice from can help you deal with these issues before you get to them. And like our AI host said, making sure that you're training your law enforcement officers, making sure that you have a formalized system in place for these sorts of decisions, or administrative fees, for example. So really, overall, keep these cases in mind as you go forward and as you review your systems, so that your municipality can keep getting better and doing a better job for its citizens.
Well said, Alex. It is a regular meeting, though. We do have to have public comment. This month, we received a question about free speech in schools, which ties into some recent case law. Can a public body, specifically a public school, limit whole categories of speech in a limited public forum like school walls? Alex, what do you think?
Well, this question was actually addressed in the Seventh Circuit case of E.D. versus Noblesville School District. In that case, a high school student established a pro-life club and sought to post flyers with political slogans on school walls. The school administrators required revisions to comply with their neutral content rules for all student club wall postings. So that rule restricted all student club flyers to the club's name and the meeting time, date, and location, banning all political content. The court acknowledged that the school walls were a limited public forum for student expression, but crucially, the court found no constitutional violation because while the policy regulated content, it did not discriminate based on viewpoint, since it banned all political content from all school club flyers. So it wasn't limiting it to any sort of specific club type or viewpoint type. It banned it across the board, all political content from all school club flyers. So the court determined that the school could restrict content to create a stable, neutral educational environment and was not required to lend its resources, such as school walls, to disseminate student speech.
An interesting case and an interesting lesson for local government schools and unrelated to apply about the importance of having policies that, dictate and define those different kinds of public forum. What are the limits of the limited public forum? They were able to establish those in this case, but think, what does that mean for whatever bulletin boards and whatever else you have around your public building or around your organization, if you're a unit of government? Something to think about and lesson to take home. Before we wrap up, Alex, any upcoming publications, speeches, conferences from Ansel Glink that our listeners should know about? This is the Department of Public Works. Alex?
Absolutely. For those involved in local government and planning, Ansel Glink has a strong presence at events like the APA-IL State Conference.
That's right. The APA Illinois State Conference is October 8th through 10th at the old post office in Chicago. We've got just a few to mention. It's the Injunctions and Dragons Planning Law Fantasy Adventure on October 9th, 2025 at 1 o'clock. Dan Bolin, that's me, and Aaron Monforti will be there, along with Trevor Dick from the Village of Lombard and Phil Green from the Village of Hoffman Estates, putting on an engaging overview of intoxicating hemp and other legal topics for local governments and planners alike to learn about. And then it's at 3:30 that same day, October 9th, which is my 15th wedding anniversary, by the way. I can't wait to spend my 15th wedding anniversary at the APA Illinois State Conference. It doesn't get more romantic than that. And speaking of romance, it's GovLove, the GovLove podcast, and the APA Illinois are presenting world award-winning planners. We're going to be talking to one of the award winners from the APA Illinois Chapter Awards, Dan Bolin, that's me, and Andy Cross from the APA Illinois Chapter Only Planners in the Building podcast, teaming up again for that one. And then on October 10th, the next day, e-scooters, e-bikes, and public camping regulations with Megan Mack and Tyler Smith from Ansel Glink, strategies for municipal planners to avoid legal roadblocks. These are some hot topics. I encourage you all to check them out at the APA Illinois State Conference at the old post office. Alex, any final thoughts before we adjourn this heated session of artificial intelligence versus Alex intelligence? What do you think?
Now, although AI did a very good job here and they can provide a useful overview, nothing beats the nuanced understanding and expert analysis that human intelligence brings to these complex legal matters. So you really got to stay informed about these cases. It's just crucial for local governments and employers to proactively shape their policies and practices.
Well said, Alex. For our listeners, we hope that this recent case law update has provided you with some helpful insights. Remember to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Send us your questions and show ideas to podcast@answerlink.com or call the Quorum Forum hotline at 312-604-9185. And as always, you can visit us online at quorumforum.answerlink.com. Can I get a motion to adjourn? So moved. All in favor? The ayes have it. We'll see you next time on Answer Link's Quorum Forum podcast.